Hi, I'm Stephanie Stephenson. I'm a note editor on the Touro Law Review. Welcome to the Touro Law Review Podcast. I'm here today with Professor Lisa Pomerantz, who will introduce the topic that we're here to talk about today.
Hi, everybody. I'm really excited to be here. And so today we're here to talk about what I have termed the arbitration paradox. The concept was first described in an article I co-wrote with my colleague, Michelle Riley, who teaches at Columbia in 2015, after the American Arbitration Association amended its commercial arbitration rules. Those rules were just amended again, effective September 2nd, 2022, and it's a great time to revisit some of the ideas in that article in light of those amendments. So let me explain why I think that this topic is really important. As my students who take arbitration with me, including Stephanie, know, I think it's really important that if attorneys are going to recommend and use arbitration to help their clients resolve conflict, that they know how to do it in the most effective way. And so that will really be the focus of our discussion today.
Thank you so much, Professor Pomerantz. Now, I want to also just turn it over to you to introduce yourself, explain some of your background and experiences as well in the arbitration community.
Sure. Okay. So I graduated from Harvard undergrad in 1976, and then from BU Law School in 1979. I clerked for a year for a federal judge, and then spent 7 or 8 years as an unhappy litigator. And I then made a career transition and spent 15 years as in-house counsel for NEC, where part of my responsibilities included managing dispute resolution. For the last almost 20 years, I've had my own law practice. And for that time, I've also been an arbitrator and mediator for the American Arbitration Association, and a mediator for other panels and organizations. And for the last 4 or 5 years, I've been fortunate enough to teach at Touro Law School.
Thank you. And I just want to say that you bring great experience, and we are thrilled and grateful to have you at Touro Law teaching us those necessary ADR skills. I just want to take a moment to introduce myself to the listeners. Again, I'm Stephanie Stephenson. I am a third-year law student at Touro Law Center. I am a note editor on the Touro Law Review, and I like to stay pretty active in the academic community at Touro. So in addition to those duties, I'm also the ADR Society president, who Professor Pomerantz serves as our academic advisor. The ADR Society, one of our goals are twofold. On one hand, it's to educate the student body about ADR practices and bring speakers that will educate them to that effect. And also on the other end, it's to get students involved in building those practical skills. So we do plan in March of 2023 to participate in the New York State Bar Association mediation competition. And we did put together a really great team, and we are excited to see them go forward and compete. And just a few other things that I like to stay involved in at Touro. I am also the Black Law Student Association Vice President, and I am a co-director in our elite program, Legal Education Access Program. And that program serves to tutor students, particularly 1L students, on some of those first year topics. So that's enough about me. I want to go over to turn things back to Professor Pomerantz to explain and discuss her article that she did co-wrote with Michelle Riley. which is called Arbitration Paradox, or rather, Overcoming the Arbitration Paradox Towards a More Collaborative Approach to Commercial Arbitration. So if you can, Professor Pomerantz, please just explain what the article is about.
I'll be happy to do that, but before I get to that, I also want to mention that Stephanie was on the Touro Law School mediation team, which made the finals of the New York State Bar Association competition this spring, and which I think has really prompted increased student interest in all methods of dispute resolution at Touro. So let me give you some history of the article, Overcoming the Arbitration Paradox Towards a More Collaborative Approach to Commercial Arbitration. So roughly a decade ago, there was the perception in the arbitral community that the users of arbitration were complaining that it was not expeditious and cost-effective as it was intended. And there was a lot of discussion about how to address that situation. And I think the perception among arbitrators was that counsel's lack of familiarity both with drafting appropriate arbitration clauses and with how to represent their clients in arbitration was actually contributing to the very problem that attorneys were complaining about. And I had a discussion with Professor Riley about this. And I mentioned, and I should say both of us have similar backgrounds of having been in-house counsel and mediators as well as arbitrators, that we had observed ourselves using mediation skills in the arbitral context to try to induce counsel not to use the most adversarial and expensive and litigious approaches, but to try to obtain their cooperation with us in our mission, which as an arbitrator, our goal is to have a fair and efficient process. And I would add to that, that I also see our goal as deciding disputes correctly based on the relevant facts and the applicable law. And so at the same time, there were some articles that had come out advocating for a muscular approach to arbitration, where arbitrators were being encouraged to, if you will, override the choices that the parties had made in their contracts and disregard their expressed preferences for how to run the process. And that approach struck us as being contrary to the essential nature of arbitration, which is essentially a result of the parties agreeing as to how they were going to resolve their disputes. And so this prompted us to write an article illustrating how mediation techniques could be used by the arbitrator in conferences with the parties to yield a more fair, efficient, and, if you will, accurate dispute resolution process.
Thank you. And I'm in arbitration currently, and I read this article and I found it very fascinating, how you really parallels this issue. And I just wanted to take you through a few questions that came to my mind, just regarding this arbitration paradox. So something you mentioned is that the parties in arbitration, they're volunteering to participate because they see it as the most efficient way to resolve disputes, which suggests to me that they subscribe to the benefits of arbitration. So how do you, as an arbitrator, make attorneys participating in arbitration recognize that the behaviors that they engage in either delay or increase the expense of the arbitration process? Is there a way that you remind them of their overall goals in arbitration?
Well, one thing that I do share with the parties is how I see my responsibility as an arbitrator. And I explain to them that as an arbitrator, I'm responsible for ensuring that the process is cost effective and fair. And so when the parties are engaging in behavior that results in either delays or additional costs, what the article suggests is, rather than criticizing them, is asking good questions. Like, how will that proposed motion contribute to a fair and expeditious process? How do you see it shortening the hearing that we will eventually need to have? Or parties who insist on having depositions, which generally are only to be used in large cases, asking the parties, and what do you see as the probative value of this deposition that couldn't be obtained from documents? Or might it make sense to get documents first and then evaluate the need for depositions? So I think that approach, where we're using questions, general questions, and then clarifying questions, is a more respectful way. And it's helping the parties focus on the issues that we, as arbitrators, need to focus on in designing the process.
Definitely. And that's very helpful to know. And I'm sure you've seen so much in your experiences as an arbitrator and, of course, as a mediator. So even with the fact that you've termed this a paradox, do you think, in your own opinion, that arbitration is still the best ways for the parties to resolve their dispute despite some of these behaviors? Or do you think that there is a point in the process that the parties are just so adversarial that they may be better off litigating their claims?
I'm really a big believer in arbitration, and I believe that the facts bear this out. As you know, Jeff Zano, who is the vice president for the American Arbitration Association, came to speak to our class and the ADR Society. And he mentioned studies that show that arbitration is definitely more expeditious, and that really the main costs involved in arbitration are not arbitrator fees or AAA fees, but they are attorney's fees. And there also was an even more recent study done by the U.S. Chamber of Commerce, which compared arbitration in commercial and employment contexts, and found that dispute resolution was faster, and actually that consumers and employees prevailed more often in those contexts than they did in the courtroom setting. So I think that, first of all, a big advantage of arbitration is that you can select a neutral who's knowledgeable about the applicable law, who might be familiar with the applicable industry, and also that there is a very robust system of quality control in the arbitral context. After arbitrations are completed, the parties fill out evaluations as to whether the arbitrators were in fact fair and diligent, and so that arbitrators who are not fair and diligent will not be kept on the panel. So, and the other thing, and this is difficult to measure, but I believe, and I think we mentioned this in the article, is that when the arbitrators get the parties working together to figure out the most efficient process and to focus their attention on the issues that are truly in dispute. And actually, some of the things we talk about in the article is how the 2013 amendments to the rules gave the arbitrator more leeway to identify the issues that are in dispute, to discuss what evidence should be produced. That when you get the parties working together, and I've seen this many times, that it actually prompts them to engage in settlement discussions. So I know that most cases that go to arbitration do settle, but I think it's difficult to measure the positive impact of a more collaborative process in arbitration on how, on the willingness of parties to settle, and actually probably on the quality of the settlements they reach. But I think that that is an important factor also.
Yeah, definitely. And I do tend to agree with your points with regards to arbitration, because even though my experience with litigation is pretty limited to the time I've been working, I could see that litigation is just this very long, drawn out process that, even in circumstances where the parties are not acting to like the optimal benefits towards the optimal benefits of arbitration, I think it's still definitely more efficient and cost-effective process than litigation would be. So I just want to put out a different idea, just thinking back to some earlier points that you made. Many arbitrations are proposed well before a dispute arises, and often the attorney that's involved with drafting the arbitration clause is not the same attorney who will represent that party in arbitration. So how can transactional lawyers understand how to draft more efficient arbitration clauses?
I think you've touched on a really important point. And as you know, in our arbitration class, the first thing that we did was draft a clause. So I think that it's really important for those attorneys who are involved in the negotiation and drafting process to be familiar with what are the variables. And the AAA has a tool called Clause Builder, which actually is very helpful in walking attorneys through the drafting process. I also, and some important variables are which rules are going to apply, and to make sure that if something should be decided, for example, under the employment arbitration rules, that you don't specify a different set of rules. And as you know, in our class, we've had the students give reports about all the different rules for special circumstances, such as accounting malpractice. And those sets of rules have incorporated in them both panels who are especially qualified to hear those disputes, as well as procedures. There might be standard discovery procedures or something like that that are especially suited for that kind of dispute. So some of the issues are what rules should apply. Are you going to really need an evidentiary hearing with live witnesses, or might you need, might something be resolvable on the documents? A big issue in the drafting process is that some attorneys, especially if they're in the context where it's a contract of adhesion or one party has more negotiating power, they'll write the contract to be very one-sided. So one side gets more access to discovery than the other, and they don't recognize that they're causing a dilemma for the arbitrator, because the arbitrator's goal is, one, to enforce the agreement as written, but secondly, within the constraints of providing a fair and expeditious process, and a one-sided clause might not be consistent with that process. And if the process is not fair and expeditious, as you know, there might be grounds for vacating it under the Federal Arbitration Act or the New York equivalent. The parties can stipulate as to the credentials for an arbitrator. They may want to do that. And they may want to limit discovery, and they may want to insist that an arbitral decision be issued within a certain number of days or months after filing. So both to avoid what we call toxic arbitration clauses that are very difficult to enforce as written, and to take the best advantage of the process, those attorneys who draft clauses should become more familiar. And I know I've spoken on the topic of drafting dispute resolution clauses, both for the New York State Bar Association and for the Suffolk County Bar Association. And so I would encourage attorneys who are representing their clients in transactions to take advantage of that kind of training.
Thank you. That's definitely helpful. And you touched on this point, I think, several times. But I'm going to still pose the question. And it's this: how do you feel empowered as an arbitrator to uphold this mission of arbitration to be fair and efficient? What are some of the key things that you turn to make sure that you uphold this mission?
Well, one thing I do is share with the parties that is my mission, especially if one side or the other is being especially contentious or filing unmeritorious motions. Sometimes counsel are not familiar with arbitration, and they try to do things that are inconsistent with the rules. So I'll just remind them. This happened this week, for example. Somebody tried to have a subpoena, me sign a subpoena, but the rules require that they consult with the other attorney first before coming to me. And so I just pointed out the applicable rule and asked them to consult with the other attorney, and said I wouldn't take any action until that happened. But as the article discusses, unlike judges, the arbitrators have authority to identify what they see as the key issues, to ask the parties to focus their attention on them, to suggest that allowing the parties to make dispositive motions on those issues, or to bifurcate the case to focus on those key issues might be appropriate. And I often will suggest those kind of approaches to the parties and try to elicit their agreement that, oh yes, well, maybe we should, have dispositive motions on the applicability of a contractual limitations provision, or on a limitation of liability provision or something that might really either narrow the case or decide it entirely. And arbitrators also, and this is another difference from judges, we do have the authority to ask questions of witnesses and also to require the production of evidence that we think might be relevant. So, and I know different arbitrators have different approaches. I tend to be something of an activist arbitrator, and I really try to get at the heart of the dispute and make sure I've considered all the relevant facts and the relevant law. I think I mentioned in class that we once, on a case that involved trade dress infringement, we asked for the parties to produce the actual products. And I often will ask questions of the witnesses, and sometimes I see legal issues that the parties might not see themselves, and I'll ask them to brief those issues for me.
Thank you so much. And it sounds like the common theme that I see running as you speak is that really focusing on the rules to ensure that fairness and efficiency, because the rules are set up to be fair and efficient. So when all else fails, if you go back to the rules, you could make sure that the parties are doing what they're supposed to be doing. And the discovery process is something that's very familiar to both litigation and arbitration, but it's much more streamlined in the arbitration process. And discovery is a significant part of litigation. And in the article, it was mentioned that litigators who participate in arbitration often are uncomfortable with expediting the discovery process. They often want to collect as much information as possible to see if they could gain an advantage on their counterpart. So, how do you remind those attorneys that maybe this approach of trying to gain an advantage is not encouraged in arbitration?
Well, again, as you point out, the rules spell out a narrower scope for discovery. So I remind them, that we need to only allow discovery of what's relevant and material, not just anything that will lead to the discovery of, relevant information. And again, I ask questions like, what do you see that you're going to get out of taking a deposition or asking interrogatories? And the other thing is that clients are encouraged to attend conferences with the arbitrators. Sometimes the attorneys don't want them there, but when the clients hear that the arbitrator is, if you will, asking reality testing types of questions about the need for discovery, especially in light of the associated expense and delay, it forces the attorneys to actually consult with their clients about the need and value of that discovery, which is something that attorneys ought to do, as you learned in Inc. Interviewing, negotiating, and counseling with me, but does not always happen. That attorneys often don't consult with their clients, and they, I think, engage in too much discovery. They're afraid to leave some stone unturned. There is a financial benefit to conducting extensive discovery, and it might be just what they're used to. But again, the rules are pretty clear. In expedited cases, if it's under, I think, 25,000, there's not even an evidentiary hearing, and the case is decided on the documents. And only in cases over, and I think the amount just got raised, it was $1 million, are depositions expected? So the rules do empower us to point out that extensive discovery, including depositions, etc., is not really expected except for in larger cases.
Thank you. So just turning back to the arbitration clause for a moment, because as discussed previously, many parties will begin arbitration stemming from the fact that they agreed to this in their contract. So, how do you handle cases where the party to the arbitration has a clause that does not encourage efficiency? Would you encourage them to adopt a more expedited approach now that they do have the dispute ongoing?
Well, I would encourage it. I mean, there's two situations. One is where one side has the right to extensive discovery and the other side doesn't, where I point out that that approach is not consistent with my responsibility to provide a fair process. And I do point out to them that it's in everybody's interest to have a fair process so that I can issue an award that's not subject to being vacated. I will say that where the parties have agreed to more discovery than I think might be necessary, but they both agree to it, and we have a discussion as to whether it's truly necessary. And they insist on it, and it's provided for in the clause. It doesn't violate the rules to have more extensive discovery, so I will defer to the clause as long as it doesn't violate the rules, if I cannot persuade the parties that perhaps the amount of discovery that they are seeking is not necessary.
Thank you. And we did talk about your article in our arbitration class. And I know after I read it, one question did come to my mind, and that was the interplay between professional responsibility and arbitration. From a professional conduct perspective, is the attorney obligated to pursue the best terms for their client in the arbitration clause? Do you have any thoughts on this interplay?
Yes. We also discussed the zealous representation issue. And actually, I did the research, and the zealous representation is, that language was taken out of the commentary to the New York rules. But I think the job of the attorney is to represent their client most effectively in whatever the applicable forum is. And if that's in arbitration, then the job is to represent your client most effectively in that forum within the scope of the rules. And I would say the New York Standards of Conduct and the Rules of Civility do not allow tactics which are solely for the purpose of raising frivolous issues or imposing unnecessary burden or delay on the other party. And the rules definitely apply to attorneys representing their parties in arbitration. And I think one of the things, to get to the question of how the recent amendments to the rules further empower the arbitrator, is that they specifically incorporate by reference the standards of conduct for parties and representatives. I had actually made those standards known to counsel in arbitrations that I was presiding over when I thought that there was lack of regard for those standards. But I am very pleased that they have now been officially incorporated by reference. So there's no question that they are applicable, and also that they are now being made known to counsel who are representing their clients in arbitration.
Thank you. And just kind of going to that idea that the new rules, the 2022 amendments to the commercial rules, incorporate by reference the standard of conduct for parties and attorneys. Can you give us some thoughts about how you think this will change the future of arbitrations?
Well, I think hopefully it will promote a more collaborative approach and cooperative approach on the part of counsel. And I think a really important point that we touched on in class, and I'm really curious to see how this plays out, is this. Up until now, although arbitrators had authority to issue sanctions for failure to comply with the rules or arbitrator orders, those sanctions could only be issued against the parties because the parties had agreed to be bound by the contract, which incorporated by reference the applicable rules. Now that the applicable rules incorporate the standards that are applicable to both attorneys and parties, I think that there might be an argument that arbitrators have the authority to sanction attorneys as well, because by representing a client in an arbitration, the attorney is agreeing to abide by those standards. And if somebody on the law review wants to pursue this question, I would encourage it for an article.
Thank you. And just as one final question, in general, what is the best advice that you can give to attorneys, including new attorneys, about how they could avoid the arbitration paradox?
Well, what I would say to attorneys is to do their due diligence and make sure that they are practicing in an area where they are knowledgeable, that if they're representing their client in arbitration or drafting an arbitration clause, that they've read the rules and know what their clients are agreeing to and discuss that decision with the client, so it's not a surprise to either one. And I think this idea of working hand in hand with your client is something that's really important, and as you know, is something I do focus on in Inc. as well.
Thank you. And that's really all the questions that I have today. I don't know if you wanted to add anything else to the discussion as far as like final comments, points that you want to raise before we just wrap things up.
Well, I would just say this also, that it's important when you are representing clients in arbitration that you understand what the arbitrator's mission is, and also understand that engaging in tactics or approaches that obstruct or burden the arbitrator's efforts to carry out that mission will not endear you to the arbitrator. Now, I really, really try as an arbitrator not to be biased against parties whose attorneys may engage in such tactics. And I really try to focus on the merits of the dispute and address each issue as it arises in the arbitration on its own merits. But I certainly think taking a cooperative and collaborative approach in arbitration will put you in good stead with the arbitrator and should also be kept in mind. I also want to say that I know that this is the first instance where a student has handled the podcast, and I'm really excited that you got the chance to be the trailblazer in that respect.
Thank you for that. And thank you, Professor Pomerantz. I really did enjoy this discussion today and generally have really enjoyed taking the arbitration class. It's really gained a better appreciation for arbitration and the process. And I know we talked before that prior to law school, one of my roles while working in the insurance context was serving as a property damage arbitrator for the American Arbitration Association. And I learned so much skills just doing that role. And that particular role was just determining the outcome based on just the papers. But you really did have to put on this neutral role and be fair based on what the parties submit. And I'm hoping to really leverage the skills that I learned from your class and the skills that I came to law school with as I go into my career in the corporate space. And I definitely would keep in mind what you said with regards to how transactional attorneys could improve their skills to make sure that they are drafting the best arbitration clauses or putting them in all together, in my opinion. I want to say thank you to the Touro Law Review for the opportunity to have me on as the first student speaker. And Professor Pomerantz, I just want to turn it over to you to just, give your last final thoughts before we wrap up.
Well, again, I'm delighted to have had this opportunity, and I encourage anybody in the Touro community or elsewhere who has any questions or thoughts to share them with us.
All right, thank you, and thank you for listening.